camera there, can you see the form that has your
Yes,
name and plead guilty on it and case number?
Yes, sir.
Alright, and on page 3, there are signature lines, and near the top is a sentence that says, I enter this plea voluntarily, and then a signature looks like Dusty Cox. Again, I'll hold that up, and it's actually your signature there.
Yes, sir.
And when did you sign this agreement, Mr. Cox?
I think it was, what day was it?
It was Monday morning.
Yeah, Monday. I was gonna say, I was thinking Friday, but, Monday.
And your attorney was with you when you signed it there at the jail?
Yes, sir.
And did she go over with you and explain everything to you and answer your questions?
Yes, sir, she did.
And you understood that when you signed the agreement, it was an agreement to plead guilty, which means there won't be a trial, and next step in your case will be sentencing hearing.
Yes, sir.
And do you feel you had enough time to fully consider this matter before making this decision?
Yes, I do.
Were you feel you were forced or rushed in any way into making this decision?
No, sir.
You're entered into the agreement to plead guilty voluntarily.
Yes, sir.
Right, now this agreement states on page 1 that you're going to withdraw your not guilty plea and plead to the charge in the indictment of aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code 853 felony. And it further states you understand that the maximum penalty for that, if convicted, could be 12 months in prison, the minimum would be 6. There could be a fine of $2,500. There could also be a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
And I know you're serving a prison term currently. Are you facing any other charges in any other jurisdiction?
No, sir.
Now, if you are convicted in this case and sentenced to prison, then the charge could be served, the order be served secondly to that current charge, meaning in addition to it. So it would extend your out time on your commitment by whatever the sentence is in this case. You understand that?
Yes, sir.
Now, under the law, Mr. Cox, if you are convicted of this offense and sentenced to prison, once you complete the prison term ordered by the court, it is possible that the adult parole authority may choose to put you on close release control supervision for a period of up to 6 months. It's optional, meaning they will make that decision. They don't have to, but they'll decide. And they make that decision, not the court. The court has no call. If they decide that you should be supervised, then they will put you under the supervision of a probation officer on the term they set. If during that period of time they determine that you have failed to comply, then they can return you to prison even though you served the entire term set by the court for an additional period of up to 1/2 of whatever term is ordered served by the court. However, if you are convicted of the felony on close release control supervision, then in addition to whatever sentence that judge in the new case would impose upon you, that judge could also sentence you in this case for committing that new violation to an additional period of 1 year, whatever time's left on that period of close release control, whichever is greater. That occurred, that would have to serve consecutively the sentence in the new case. You understand that?
Yes, sir, I do.
Now, under the law, I'm not required to sentence you to prison. I can't impose what's called community control or probation. And that means that instead of being sent to prison, put under supervision probation officer for a period of up to 5 years under term set by the court. During that period of time, the probation department felt that you were not compliant. They would file a written notice of that with the court. There would be a hearing, and the entitled to be represented by counsel. And if the outcome of that hearing was that you failed to comply, then at that time, the court would sentence you to 12 months, fine you $2,500. You understand that?
Yes, sir.
All right. Now, the charge alleges that on or about September 9, 2020, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of 2925.11 of the Ohio Revised Code. So again, that's a charge of aggravated possession of methamphetamine, a 5th-degree felony, with the penalties I have just described to you. Now, do you understand the nature of the charge and possible sentences for that offense?
Yes, sir, I do.
And you understand what the state accused you of having done in that charge, when, where, and how they alleged you did it?
Yes, sir, I do.
Now, have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible defenses might try to raise a trial, and the possible outcomes of a trial with your attorney?
Yes, sir, I am.
Are you satisfied with your advice and competence in this matter?
Yes, sir, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, I'm not.
Are you taking any prescription drugs?
No, sir, I'm not.
Have any threats been made against you plead guilty here today?
No, sir, there hasn't.
Now, on page 2, in the middle, there are 3 more sentences that are printed in bold and underlined. You see those?
Yes, sir, I can.
And you see part of them have been marked out, which indicates to me that they're not applicable. See
Yes,
that?
sir.
Okay. So I'm going to read to you the part that's not stricken out. And it says, the defendant shall enter a plea of guilty to the indictment. State defense jointly recommend 6 months. It was originally 9. It's been marked out, and 6 has been written in ink. 6 months incarceration consecutive to the term of incarceration. Defendant is currently served in the case number 21CR022. Now, is that your understanding of the agreement, Mr. Cox?
Yes, sir.
And has anyone promised you anything other than that to get you to plead guilty here today?
No, sir, there hasn't.
Now, under the law, the matter of sentence is reserved to the judge, so I'm not required to follow the sentence that's recommended. If you plead guilty, once I've heard all the information presented, I could decide that's not the proper sentence. We could sentence you to as much as 12 months consecutive to your current sentence, plus fine you $2,500 and suspend your license for 6 months to 5 years. You understand that?
Yes, sir, I do.
Now, do you hold any license or certification from any state board or any occupation or profession?
No, sir, I don't.
And you have certain constitutional rights. You must understand, Mr. Cox, before I can accept this plea of guilty in front of you. First, you have the right to have counsel. This happens appointed representation. Now, that wasn't simply to work the case out, but to provide any defense might be available to you under the law that you wish to provide. So if you decide that you do not want to plead guilty, you'll still be represented by Ms. Hafford, and she'll defend you, including a trial if that's what you want. You understand that?
Yes, sir.
Right under the Constitution, Mr. Cox, you have the right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county and are subject to jury duty by your trial. After they are selected, the evidence will be presented, they be instructed on the law, by the judge, and then they will decide whether or not to say prove your guilt or prove beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing which means to give up the right to have a jury trial. And then in that case, you would have to hold a court or bench trial meeting instead of a jury hearing the evidence. It would be the judge who hear the evidence, apply the law, and decide whether or not to say prove your guilt by proof beyond a reasonable doubt. You understand that?
Yes, sir, I do.
Right under the Constitution, Mr. Cox, you have a right to confront the witnesses against you and cross-examine them in open court through your attorney. What that means is witnesses have to come into court and testify from you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. And the purpose of that is trying to bring out evidence that helps your side of the case. You understand that?
Yes, sir, I do.
Right under the Constitution, Mr. Cox, you have a right to use the power of this court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses that you're not certain come in voluntarily, to request court issues a court order as a subpoena, force those witnesses to come to court to be available to testify if you want them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come into court to testify. You understand that?
Yes, sir, I do.
Right now, Mr. Cox, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. You decide not to testify. The fact that you did not testify, you can do it any way by any person at any time. No one's even allowed to comment about it except in one situation. That is, if there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir, I do.
Right now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is the burden of proof isn't on you to try to show you're not guilty. The burden is upon the state to prove that you are guilty. They must do that by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof known under the law. And if it is a jury trial, all 12 jurors would have to agree. You understand that?
Yes, sir, I do.
Right now, you originally entered the plea not guilty, Mr. Fox. That plea denied the allegations in the indictment, denied you committed any crime, and it exercised or revoked all of the rights that I've just described for you. If you change your plea from not guilty to guilty, that is the opposite of not guilty. The guilty plea admits that you committed the offense, and That plea waives all of the rights I've described for you here this morning, except the right to have an attorney, which you always have no matter what your plea is. With that exception, your plea of guilty waives gives up the right to a jury or court trial, waives gives up the right to confront this issue and cross-examine through your attorney, waives gives up the right to use the power of the court to compel or force the Supreme Court to testify for you, the same as the state. Waives gives up your presumption of innocence or your privilege against self-incrimination because you're the one saying you're guilty, that's what she can find you guilty. It waives gives up your presumption of innocence because you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court, which is what's likely to happen. And finally, it waives gives up any right to file an appeal that you think you may have filed, you may have had up to this right at this point in the trial, case. Now, if I sentence you to maximum sentence under certain circumstances to file an appeal, that would have to be filed in 30 days for sentencing after you're due filed. You understand all that?
Yes, sir, I do.
And Mr. Cox, are you a U.S. citizen?
Yes, sir, I am.
All right, now, do you have any questions about the charge or possible penalties?
Yes, sir, I do not.
You understand it?
Yes, sir, I do.
Do you have any questions about the plea agreement?
Yes, sir, I do not.
You understand that?
Yes, sir, I do.
Do you have any questions about any of the constitutional rights I've explained to you this morning?
Yes, sir, I don't.
Do you understand those?
Yes, sir, I do.
Do you have any questions about the plea of guilty or what it means, what the consequences of that will be if you enter here this morning?
Yes, sir, I don't.
You understand?
Yes, sir, I do.
And is there anything you'd like to speak with Ms. Hackner about before we go any further? You can do that
Yes, sir.
privately if you need to.
Yes, sir.
Do you have any questions about anything that I explained to you here this morning?
Yes, sir, I do not.
All right, then, Mr. Cox, is it your decision to withdraw your not guilty, plead guilty to the charge and the indictment of aggravated possession of methamphetamine as we discussed in this written plea agreement?
Yes, sir, it is.
That ends to the charge which alleges that on or about September 9, 2020, in Huntington County, Ohio, you did not only obtain, possess, or use a Schedule II controlled substance to wit methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony, carrying a possible prison term if convicted of between 6 and 12 months, a fine of $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Right? Court finds in this state open court, the defendant was advised of all his constitutional rights, make no attempt to voluntary waiver of sentence under criminal 11. The plea is accepted and ordered filed. Then is found guilty of count 1 of aggravated possession of methamphetamine as charged in the indictment. The matter is not referred for a pre-sentence investigation since there is a stipulated recommendation for sentencing. The defendant is already serving a prison term. The court doesn't feel that there's any need for that, and we'll go ahead and proceed with sentencing for Mr. King. Anything we have to say?
Only that's contained in the plea agreement, Your Honor.
Just happen.
Thank you, Your Honor. We do ask that you follow the recommendation. We do realize that this is a minimum sentence. However, he is currently serving a term of incarceration of 15 months, so we believe that the sentence does adequately protect the public and punish the defendant in this case.
All right, Mr. Cox, do you have anything you'd like to say?
No, sir, only that, I accept, anything you send me to, I'm guilty and I believe I deserve to be punished.
All right. Well, court will note that you're already incarcerated and you have cooperated and been very accepting of your responsibility in this matter. So the court will accept the recommendation of the parties and award the court to be hereby sentenced to a term of 6 months incarceration, Correctional Reception Center, or Ohio, which will be served consecutively to the sentence you're currently serving. The court finds that the second sentence is appropriate since it's part of the recommendation and the offense is committed in one or more courses of conduct, and one single sentence is not accurate reflect the seriousness of the charge, and it is not disproportionate to the offense this being the sentence, and the defendant's prior criminal history will indicate the defendant's appropriate sentence for protection of the public. The defendant is also ordered to pay the court costs, which is the grant execution order, And if you don't make those payment, you don't pay those costs, Mr. Cox, and the clerk will collect that through various means, including bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you complete your prison term, you can be required to do free service in this county and be given credit for each hour you work. In and out of the rate set by the court, each hour you work, reduce your judgment by that amount until paid in full. According to the sheriff, there's no jail time credit day because you were, all those days were credited to your earlier sentence. Now, on completion of your sentence, it is possible the adult parole authority in their discretion may decide to put you in post-release control for a period of up to 3 years. Strictly up to them, the court has no involvement. It's optional, it's not mandatory, but they'll make that decision, and if they put you under post-release control, it could be for up to 3 years under the supervision of the terms they specify by parole officer. And if that, the APA decides that you have not complied with those conditions, then they can return you to prison until you serve the entire term set by the court, for an additional period of up to 1/2 of your prison term for one or more violations. But if your violations have been done, then in addition, whatever sentence the judge in the new case would impose upon you, the judge would also sentence you, in this case, for committing that crime while under post-release control for an additional period of 1 year, or whatever time might be left on that 3 years of post-release control, generally greater. If that occurs, then has to serve consecutively the sentence in the new case. All right, is there anything further for counsel? All right, then you'll be returned to the institution in the next couple of days by the sheriff's department, and they'll notify of this additional sentence. Thank you.